पास होगा।
वास्तव में केस आइटम है WBC 957 of 180.
डिसाइड कर देते हैं, चलिए अपील अपना डिसाइड करेंगे।
Your Lordship, one thing I wanted to, I thought it should not escape your notice, Your Lordship, Your Lordship notice.
क्या?
This was not brought on record. This changes the complexion of the whole case. बीच में माइक कैमरा आपका जो है ना व्यू को डिस्टर्ब कर रहा है, थोड़ा सा इसको आगे पीछे होना चाहिए।
अच्छा
आपको देख ही नहीं
इसको सही है,
थोड़ा सा
ये तो फिक्स किया हुआ है।
कोई बात नहीं, we can relocate ourselves.
हाँ।
The order is on the premise that my factory has dumped some coal char on the land said to be forested, and therefore that encroachment should be removed. Just give me half a minute. Just give me half a minute, please. Now, during pendency of this petition, something has happened. Your Lordship asked my junior also this question. Environment clearance was granted with the condition that I should do this, and the DFO himself has allowed this. So now that is not to be removed. Therefore, this order should go, and the notice in any case should. Notice says removal के लिए खर्च दीजिए, तो removal तो करना नहीं है।
तो वही हम बताइएगा ना, हम लोग यहाँ से नहीं।
वो आपके पास नहीं था ना, और ये डॉक्यूमेंट सामने था।
कोई बात नहीं, मेरा ये कहना है कि आपका ये जो इम्प्यूग्ड ऑर्डर है NHS 7G,
जी,
it has been passed
NHS 14 and 17.
NHS
14 and 17. 14 is the main order.
ठीक है।
That 14 is the main order. 17 only refuses to entertain appeal against.
वही अपील ने, अगर मान लीजिए अपील राइटली रिफ्यूज किया है, तो हम मेरिट पे नहीं सुनेंगे।
नहीं, हम वो नहीं कह
मेरा
रहे।
ये कहना है।
समझ गए, हम वो नहीं कह रहे। अपील तो मेरिट पर सुनाई नहीं गया था, लिमिटेशन के ग्राउंड पर था।
वो हम मेरिट पे सुनाई के लिए भी।
हाँ, नहीं, हम कुछ और कह रहे हैं। ये कह रहे हैं कि हुजूर उसको अप्रिशिएट कर सकते हैं। तो अब मेरिट पर सिनेरियो बदल गया है। वो ऑर्डर था कि आप रिमूव कीजिए, और अब रिमूवल करने की जगह पर हमको कहा जा रहा है कि फॉरेस्टेशन कीजिए।
आपको बोलना है, आप एपिलेट
बोल सकते हैं, कोई दिक्कत नहीं। लेकिन खाली लास्ट वाला जो नोटिस है उसको तब से डिसाइड करिए।
लास्ट वाला कौन सा?
उसके साथ एक नोटिस भी दे दिया, तो नोटिस इन एनी केस इलीगल था।
कौन सा?
NHS 20, दैट शुड बी सेटिस्फाइड। NHS 20 सेज कि आपको पैसा जमा करना चाहिए, खर्चा फॉर रिमूवल जो आप नहीं कर रहे। और अंडर सेक्शन 7 आई गॉट टू से ओनली 2 थिंग्स। अंडर सेक्शन 7 रिमूवल करने पर जो खर्चा इनकर करेंगे वो हमसे रिकवर कर सकते थे, बट अब वो सिनेरियो बदल गया, तो रिमूवल करना ही नहीं है।
इसका इस नोटिस का कितना जस्ट इस नोटिस का क्या इम्पैक्ट होगा, वो तो एपिलेट ऑर्डर के ऊपर डिपेंड करेगा ना।
नहीं, उसके बाद भी नहीं दे सकते ऐसा नोटिस। सेक्शन 7 का देखा जाए लैंग्वेज,
सेक्शन 7 ऑफ
यूपीएल है। Section 7 says,
remove
if I don't remove, then authorities will remove and take the expense from you.
Yes.
तो रिमूवल किए बिना मांगा है।
Prior to removal.
हाँ, तो ये एक्सपेशली अदरवाइज इलीगल था, कॉन्ट्री टू स्टैट्यूट। बट अब हम ही कह रहे हैं कि सिनेरियो चेंज हो गया, अब तो हमको रिमूव करना ही नहीं है। सेंट्रल गवर्नमेंट हैज ग्रांटेड मी एनवायरमेंट क्लियरेंस, एंड ऑन रिलाइंग ऑन दैट एनवायरमेंट।
अगर मान लीजिए आपको
तो
रिमूव नहीं करना है,
2 डॉक्यूमेंट देखिए, मार्क कर दिए मुझे उनकी कन्वीनियंस के लिए। दिस वाज द एनवायरमेंट क्लियरेंस। इसमें मेरा मार्क किया हुआ हाइलाइटेड पोर्शन है, 2 पेज के बाद, जस्ट 1 लाइन।
ठीक है। आपको सेंट्रल गवर्नमेंट ने एनवायरमेंटल क्लियरेंस कर दिया है।
द कंडीशन,
जस्ट व्हाटएवर बी द कंडीशन, वी आर नॉट बॉदर्ड अबाउट।
दैट इज इंपॉर्टेंट योर लॉर्डशिप। कंडीशन का कंप्लायंस टेक्स अवे द
नहीं,
होल
यहाँ
बेसिस
पे
ऑफ
हम
दिस
इसको
केस।
नहीं डिसाइड करेंगे ना, प्लीज अप्रिशिएट। I will go by your belief and I will go by your impugned order, and then whatever is the consequence arising out of that, whatever development has taken place during the pendency of this case, maybe that you have got an environmental clearance, maybe that you don't need to remove anything. The fact that you don't need to remove anything is also something which is required to be brought to the notice of the authority, that yes, I don't need to remove anything.
Actually, I'm not joining issues. I'm bowing down. Actually, the authority who was required to appreciate all this, TFO, original authority, has himself, जो पहला डॉक्यूमेंट पास ऑन किया, has himself authored that, जो कहता है कि आपको हम एनवायरमेंट क्लियरेंस के कंडीशन के लाइट में स्वीकृत करते हैं, द लैंग्वेज इज स्वीकृत करते हैं कि आप वहाँ पर फॉरेस्टेशन करें। रिमूवल करने की ज़रूरत अब नहीं रही है, वो अथॉरिटी कह रहा है।
देखिए, अगर रिमूवल करने की ज़रूरत नहीं है और अल्टीमेटली आपको बीपीएलई में आपको कुछ करना ही नहीं है, कि आपको कुछ ना हटाने का है ना कुछ करने का है. All consequences will follow out of that.
I'm grateful.
That is all.
Then my request is, your ladyship may remand this matter to Deputy Commissioner for
जो
consideration
भी
of
appellate authority.
appellate authority to consider all points raised, including additional points.
Including
notice should be said.
additional points and also subsequent developments
that's
which
what-
might have taken place during the pendency of this case.
But that notice to initiate 20
ऐसा आप
should
लोग इस तरह से क्वेश्चन नहीं कर सकते कोई भी नोटिस
Initiate
को.
20
Any demand
incongruous हो जाएगा ना.
इनका incongruous नहीं होगा.
अब एक
Any
बार
demand.
हम आपका छोड़ रहे हैं, आप इसको एक बार please consider this. I really feel as an officer of the court, initiate 20 should go even otherwise because of अगर वो डिमांड रह भी जाता है तो भी initiate 20 नहीं सस्टेन कर सकते.
नहीं ऐसे नहीं होता है. ठीक है.
Initiate 20 is especially contrary to section 7.
You see, it is a follow-up order of a direction to remove
No, that's what I'm
encroachment.
saying. It's a additional illegality. Even if the original order doesn't go, follow-up order वो होता है जो automatically चला जाता है या रह जाता है depending on outcome of first order. हम कह रहे हैं कि first order अगर रह भी जाता है, तब भी उसको जाना चाहिए. On that score, I'm saying let please set it aside. एक बार देख लीजिए ना language इसका.
WPC number 957 of 2018. Heard the learned counsel appearing on behalf of the parties.
And in your ladyship's last, the Honorable Court's last order has taken note of this subsequent.
This writ petition has been filed for the following relief.
Page 30.
Page 30 of what?
Page 30 of the petition is the prayer. Washment of which is 17, 15 and 20.
I have quoted the prayer.
Oh.
The learned counsel has drawn the attention of this court to order dated 12/9/2024. Wherein following observation was made in paragraph 2, which is quoted as under. The learned counsel has submitted that a proceeding under Bihar Public Land Encroachment Act was initiated against the petitioner, and an order was passed against which an appeal was filed, but the appeal has been dismissed only on the ground of limitation. He has also submitted that a petition seeking condonation of delay was filed, indicating the relevant dates with regard to receipt/knowledge of the order impugned before the appellate authority, but those sequence of events and the dates have not been properly considered. The learned counsel has further submitted that the proceeding before DFO was concluded on 25/10/2016, but till 13/1/2017 no order was passed, and the petitioner came to know about the order on 18/1/2017 and applied for certified copy. It was supplied to him on 24/1/2017, and thereafter the petition thereafter the appeal was filed. The learned counsel has further submitted that during the pendency of this case, much development has taken place. The petitioner has been granted environmental clearance, and as to the understanding of the petitioner, the so-called removal of the so-called allegation of encroachment and direction to remove encroachment/dumping has lost its force in as much as the environmental clearance has taken care of the same.
Relevance कर दिया, relevance.
Sorry?
Relevance elements has lost its relevance.
Has lost its relevance. The Learned Council has also submitted that subsequent to passing of the order passed by the appellate authority rejecting the appeal on the point of limitation, a letter dated 3/1/2018 was issued as contained in Annexure 20, asking the petitioner to deposit certain amount so that the encroachment could be removed, the alleged encroachment could be removed. But while assailing the said order, he has submitted that the question of deposit of any amount arises to pay the cost which the state incurs after removal of encroachment.
Reference to section 7.
He has referred to section 7 of Bihar Public Land Encroachment Act. He has submitted that there could not have been any ad hoc assessment for the purposes of removal of encroachment. He has also submitted that since, as per the understanding of the petitioner, there is no need to remove the alleged encroachment, therefore, the letter dated 3/1/2018, which is a sequel to the dismissal of the appeal, has also lost its force. The Learned Council, that's it. The Learned Council appealing on behalf of the respondents. Sorry?
One thing.
Yes.
As he was already said that you say all this over there. Because the DFO himself has
Yes.
granted.
इतना नहीं.
हम इसको रिकॉर्ड में इसीलिए डालना चाहते हैं.
नहीं, इतना नहीं. आप ऑर्डर नहीं डिक्टेट करते हैं. The
Order
Learned
नहीं,
Council
please.
appearing on behalf of the respondents by opposing the prayer of the petitioner has submitted that the appellate authority, having dismissed the appeal on the point of limitation, had no occasion to enter into the merits of the case. However, he does not dispute that the points raised in the petition for condonation of delay have not been considered. He has further submitted that the matter may be remanded to the appellate authority, who may consider the case on merit and also take into consideration any subsequent development as pointed out by the petitioner or otherwise, and pass appropriate order taking into consideration all the developments which may have a bearing in the direction to remove the encroachment or dumping, right? The Learned Council has also submitted that so far as Annexure 20 dated 3/1/2018 is concerned, the same will depend upon the final result of the appellate authority, and he has also submitted that after the judgment is passed by the appellate authority, if any action is to be taken against the petitioner, then certainly fresh notice in terms of section 7 is required to be given. And in such circumstances, the matter can certainly be considered by the appellate. Okay?
Yes.
After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that a petition, that's a proceeding under Bihar Public Land Encroachment Act was initiated against the petitioner in the court of Collector cum Divisional Forest Officer Ramgarh, Forest Division Ramgarh, and order was passed against the petitioner on 24/11/2016, within bracket Annexure 14, wherein the following findings have been ultimately recorded. यहाँ से para 17 का ये in view of the aforesaid discussion, page 104. The petitioner filed appeal against the said order along with the petition for condonation on delay, stating the facts regarding receipt of copy of the order and obtaining certified copy, etc. But the appellate authority, by dismissing the appeal, has simply stated that the appellate authority was not satisfied with the cause shown, without making any reference to the sequence of events with regard to knowledge/receipt of the copy of the order passed by the original authority. This court finds that the order of the appellate authority is non-speaking in many aspects of the matter. Even a petition for condonation or delay is required to be a speaking order by referring to the facts narrated in the petition for condonation or delay. This court is also of the considered view that huge stakes are involved in the present case, and therefore one opportunity is required to be granted to the petitioner so that the appeal is ultimately decided on merits. Consequently, it is also this court also finds that the petitioners has mentioned about subsequent developments, but primarily the petitioner was aggrieved by the orders passed by the authority, and the matter can certainly be taken care of by the appellate authority if there are subsequent development which has a consequence that the petitioner need not remove any encroachment, or the so-called encroachment does not survive anymore. There is no reason that the appellate authority will not take care of the subsequent developments. Consequently, in order to enable the appellate authority to consider the case on merits and also take into consideration the subsequent developments, if any, that may be brought on record before the appellate authority by filing affidavit, the impugned order dated 13/9/2017, passed in encroachment appeal case number 6 of 2017, is hereby set aside, and the matter is remitted back to the Deputy Commissioner Ramgarh to pass fresh order in accordance with law. The petitioner with the affidavit regarding subsequent developments, etc., shall appear before the said authority. एक महीना का एक डेट दे दीजिए. Upon his appearance, the appellate authority shall grant an opportunity of hearing to the parties. आप भी appear होंगे क्या? The
DFO
The-
or
respondent number,
3 years.
petitioner and the respondent number 3. उसको record लेके appear होना ही पड़ेगा. DFO कौन पास?
Competent authority of the state का दिया है.
DFO shall also appear at the first instance. Shall appear. एक महीने बाद का date. It is also observed that, considered the fact situation, if the deputy commissioners, it will certainly be open to the deputy commissioner to seek assistance from the government council, as environmental issues are also involved in the present case. The authority shall proceed The fresh order be passed within a period of 2 months from the date of appearance, and a copy of the order be communicated to the petitioner through email at the email ID which should be mentioned in the affidavit to be filed by them, and we also communicated through speed post. Upon passing of the, it is needless to say that upon passing of the appellate order, the authorities shall follow in accordance with the provisions of Bihar Public Land Enforcement Act. It is further observed that this court has not gone into the merits of the rival contention, and the appellate authority is free to pass appropriate orders in accordance with it.
Your Lordship,
Very rightly, your ladyship has used the expression removal so encroachment so called. But at one place,
You do not know.
at one place,
Because appellate authority has not decided the
Yes,
case
yes,
on
we
merit.
did
So
say.
how do we assume that there is encroachment?
ये एक जगह खाली encroachment रह गया था, उसको so called वहाँ पर भी कर
हम
लिया जाए.
करेंगे
अच्छा,
करेंगे.
Your
आपको
Lordship,
पता है
Yeah,
मेरे ऑर्डर
alleged,
में पूरा
alleged.
अच्छा करेक्शन होता है.
Your Lordship, just one thing. Your Lordship mentioned DFO to appear, DFO or his representative
Uh,
may mention.
DFO or
his
the
representative. Some authorities. Your Lordship.
or the authority.
Is it representative
Because of the record, sometimes DFO may not be able to.
Forest range
दूसरा
office-
स्टेट से क्यों नहीं
Forest
appellate?
range officers
Range
होते हैं.
officers जाते हैं इसीलिए Your Lordship.
क्यों DFO को लाज लगता है?
नहीं वैसा नहीं है
फिर
मैडम.
क्या है?
जैसे अभी DFO जो अभी वो ट्रेनिंग में गए हुए अभी हमारे
नहीं, एक बार
situation
एक
बता-
बार appear
हाँ
होंगे.
ठीक.
नहीं, एक बार
उसके
हुजूर
बाद-
यहाँ भी बुलाए थे,
हाँ.
उससे थोड़ा नाराज थे.
अरे ऐसा मत बोलिए.
रिपोर्ट जो किया था उसमें लास्ट में बहुत कुछ छोड़ दिए.
इतना नहीं
और
सोचना
उन्होंने
चाहिए.
प्रिंसिपल ऑफ दिस
देखिए
एंड
ह्यूज स्टेक्स है,
Yes.
एनवायरमेंटल
Yes,
इश्यूज है, तो इसको थोड़ा सा लाइटली नहीं लेने का.
दैट.
इसीलिए लिख भी दिए हैं कि गवर्नमेंट का जरूरत हो तो अपना असिस्टेंस ले लें और प्रॉपर्ली ऑर्डर पास करें.
Actually, by God's grace, facts have turned in such a way that that serious matter has now actually got sorted out.
Yes.
The government of India considered this on this.
वापस
वो खाली वो एनक्रोचमेंट वाला अलेस्ट कर दिया जाएगा. डीपी ऑफ
इंटरिम ऑर्डर है.
नहीं, खाली इंटरिम डेवलपमेंट्स.
पासवर्ड के साथ आइटम 18 WPL 7546 of 2011.
This application is being filed by the concerned workman for a direction on the respondents to pay the difference of areas of salary group 3 wages, less wages already paid with effect from 8/5/1990 within a stipulated period with interest thereon, and not to sit tight over the matter for an unlimited period and to pay the difference of payment. Case of the petitioner is that, madam, the Industrial Disputes Act dispute was raised and the award was passed on 25th September 1999. Award was passed in favor of the concerned workman, there are 166 workmen, 171 workmen and some are died, 166 they are entitled for the benefit. And the award has been annexed in the counter affidavit at Annex 1, page 42 is very much clear that they are entitled for the reinstatement and for the pay of the late fee from the date of the award.
Reinstatement and
Reinstatement regularized. They will be regularized. They will be regularized and the award is made up Annex 1 and page 9 to 48. Kindly see the terms of the award and then next also. Page 9 of the counter affidavit. Where is that?
page 9.
Page 9, Annex A. may I read it? In the terms of the condition, the terms of the difference, whether the actions of the management of the Kathara washery of CCL post Kathara district guilty by not making payment of the equal pay for equal work and not regularizing the service of the Sri Lakshman Kumar Murmu and 170 other workmen engaged in slurry grounds of the Kathara washery as per the corresponding category of the departmental employee of the Kathara washery is justified if not to what relief the concerned workmen are entitled. And kindly turn my lord, page 41. Page 41, paragraph 22, award, relevant portion. Accordingly, the following award is rendered, the action.
Yes, yes.
Yeah, 41, paragraph 22. Accordingly, the following award is rendered, the action of the management of the Kathara coal washery of such and such by not regularizing the service of the 166 workmen and not paying them wages on the basis of the principle of equal pay for equal work is not justified. The management is directed to regularize them in service with effect on the date of payment of date of present reference, that is 8/5/1999, and to pay them with 3 wages, less wages already paid with effect from that day. In these circumstances, the award is passed with number. And my lord, that was tested before you, this honorable court, and the award was confirmed by a division bench, and that judgment I have annexed in Annex 1, Annex page 18 to 20. That is the division bench judgment, and the according to the judgment, the award was confirmed, and page 99 I am reading, we find that the
Madam, please tell us one thing.
Yeah.
If the writ petition upholds the award, then you will have to file a petition under section 33C2 for computation of wages
no. That
or
is
for payment.
there is a Supreme Court decision we may file the writ petition, and then I have annexed that judgment also, the Supreme Court judgment.
Where is that judgment? That
Yes,
award can be implemented
Yes,
through the
award has been implemented, but that has been implemented from 1993, and they have given appointment, and they have not given the difference of wages from 1990.
Show me that judgment which says that for implementation of the award.
Yes, line is that. And it's the
Where is that?
Yes, and it's the 5. And it's the 5, that is the division, and that is the judgment passed in my order passed by this court, and WPL number such and such, the high hands of the respondent Bharat Cooking Coal Limited is evident from the facts of the case as how they had seen the workman. The award passed in the Industrial Tribunal on 24/7/1991 in deference case number 120 of 1990 for regularizing this reinstatement. For regularization and reinstatement of the workman was a first challenge before the court in CWDC number such and such. The writ petition was dismissed by a division bench of this court. The respondent then moved Supreme Court in the civil appeal number such and such, which was disposed of on 12/9/1990. The Supreme Court declined to interfere with the award made by the tribunal, but the payment of back wages was reduced to 50%, and the respondent company then filed review petition before the Supreme Court, which was dismissed on such and such. Even thereafter, the respondent company did not comply the award. The petitioner then moved before this court for filing this present petition for a direction upon the respondent to immediately and forthwith enforce the award. Petitioner relied upon the Supreme Court decision in case of Managing Director of Tamil Nadu State Transport Corporation versus such and such 2001 Volume 3 LNN 34 for the proposition that in such a situation, right by the petitioner's company for enforcement of the award is maintained. Instead of complying the award which was affirmed up to the Supreme Court, the respondent company filed counter affidavit stating inter alia that only remedy available to the petitioner is to move before the tribunal under section 29 of the Industrial Tribunal Act. Mr. Lohotagi, learned counsel for the respondent company was very fairly submitted that the case may be adjourned for 4 weeks so that the respondent company would be able to satisfy the award put up on surrender. It is made clear that in the event the respondent company failed to comply the award by that time, then the instant application shall be converted into the contempt proceeding and appropriate order shall be passed against the concerned officer of the respondent company who are responsible for non-implementation of the award. And then kindly see the next page. Next page, that is page 26. That case was listed on 13/5/2003. Writ petition was filed for making reasons that the award passed in is not implemented by on such and such date. Counsel for the respondent paid for adjournment for the case for 4 weeks to enable the company to satisfy. Today, a counter affidavit has been stating, page 26, just the next page of that order. Stating inter alia that the 37 awardees are to be reinstated and letter of the appointment shall be issued within a period of 2 weeks in view of the appointment made in the affidavit. The instant writ application disposed of, needless to say, if letter of appointment is not issued to all 37 awardees, they shall be liberty to bring the fact to the notice. Therefore, on the basis of the Supreme Court decision that was interfered and the order was implemented after the order passed by this one. In this case, my lord, they have reinstated, regularized, not regularized has been mentioned. They have given the face appointment in the year 1993. I have saying that from the counter affidavit, can you see annexure B, page 49.
And they have not regularized you.
We have regularized, we have stated.
They have said regularized, but the kindly see the appointment 49 in terms in persons of the appointment
You
letter.
just tell us what you have received and what you have not received.
I have not received the different appointments
So show me from the writ petition
from
what
the
you have received.
1990.
Please show me from the writ petition what you have received and what you have not received. Because it is not a case that it has not been implemented at all. Something
No.
has been given to you.
Something has
Now
been
let us see.
But
Now
we
let
have-
us see what has been given to you.
The benefits which we have extended is much
Please
more.
hold on. Yes, yes, madam.
देखिए annexure
Show me
10.
from the writ petition.
Yes, yes.
देखिए annexure से मत बताइए.
Annexure नहीं, पेज बता रहा है.
हाँ, page
Page 8, paragraph 10.
8 paragraph. बताइए.
That the petitioner says and submit that during the pendency of the petition, all the concerned workman has been regularized accordingly. The petitioner, while communicating the judgment dated 18/12/2002, made the representation dated 15/3/2004 before the central manager to pay the difference of arrears of salary with all consequential benefit with effect from the date of reference. In that representation, it was specifically mentioned that all the concerned workmen have already been regularized subsequently with effect from 1908 to 1993. As such, they are entitled for the difference of salary from the date of reference, that is 1990. And that the petitioner including concerned.
So you have no grievance so far as regularization with effect from 1993 is concerned.
1993 they have been.
Okay. Now you are entitled to difference of salary.
Difference. No, paragraph 12 I have stated specifically, and you see page 10, that the petitioner who prefers to post and make several representation but no action. Lastly, made a representation dated 29/6/2011 before the project officer, the general manager Kathara, reiterating that their claim and request to pay the difference of arrears of salary, wages along with the other consequential benefit with effect from 8/5/1990, for which the respondents are directed to pay the concerned workman, but till that no action has been taken. And my lord, kindly consider there is an order passed by this court.
Where is the term consequential benefit mentioned in the award?
That is the difference of salary and the other consequential benefit is that, my lord, after the retirement and whatever may be
We do
done.
not know what it, because the term consequential benefit as such is not mentioned in the award.
In the award, it has been mentioned they are entitled for the regularization.
Whatever is mentioned, you are entitled to that only.
And-
We do not know what consequential
and-
relief you are seeking.
And all the difference of salary from 8/5/1990. They are not given.
8/5/1990. How do you get that date?
That is the date of reference.
Date of
Can you see? Yes. Can you see page 20?
But you have been regularized with effect from 1993.
Yes.
So,
That should be 1990. We have stated that I should be. We should be regularized with effect from 8/5/1990. In place of that, they have issued the appointment letter or regularization letter August 1993, and they are not giving the difference of salary and fixation has not been made. And in this case, my lord, there was an order passed by this honorable court. In this case, 26/1919. Can you see that? 26/1990. It has been submitted by the Learned Council for the petitioner that as for the award date 25/9/1991.
where is the judgment of the Supreme Court?
Supreme Court in this case they have not moved.
No. The judgment which has been referred to.
Oh, yes.
You have not been paid even a penny.
Regularization after that they have fixed the payment. But I have said that we are entitled for the payment virtue of the consequence of the award that has not been paid. They have
So
taken
you want the
1993.
benefit from 1990.
90 and
Give
1990.
us the exact date.
Yes, my lord. 85. Yes, that date is kind of considered. That is an extra.
8/5/1990.
Yes, an extra one you can consider by the division bench also, the award also. That is the date of recording.
So you were to be regularized with effect from 8/5/1990,
90
and you only want grade 3.
grade 3, whatever has been paid, that has been deducted, that has been calculated, and the rest amount I am. That has not been. And
Why have you not given them regularization from
kindly
8/5/1990?
see the order dated, just 1 minute, kindly see the order dated which has been passed by this bench. That is the order dated 26/1990. Kindly see that. They were directed to make a specific appointment and to file the counter affidavit, specific affidavit, they not why they have not.
You have not complied with that order.
Madams, we have not filed the madams, but kindly allow me to just show 2 paragraphs from the counter. Just 2 paragraphs.
Do you want to say that you do want to follow?
Just for.
I want to know from you. Do you want to
What
say
is
that? Why should I hear you for half an hour?
We have
When you
extended
are
the
not compliant.
benefits which are more than what they are pleading in
We
the
do not know.
award and in the
When there is a specific order for you to file an affidavit, do you want to file it or you don't want to file it?
Just allow me a minute's time, madam.
There is
Just
no
one
question of
paragraph.
allowing any minute.
Madam, we
When
have
this order
extended
was
the
passed, it was passed after hearing you.
Indeed, madam.
Yes, then why don't you comply with this?
Because we have extended the benefit of class survey that is admitted matters from 1993. Madam, my submission
If you have
is that
extended the benefit from, you just undo everything. You just extend in the benefit as per the award. Maybe that they are at a loss. We don't bother about it.
Matters if they are agreed by the extended benefit which they have given matters and application.
You
under
revise
33C2.
everything. You recover from them.
Matters,
What is it?
application under 33C2 is the remedy which they can access.
The point is, this matter is pending since 2011.
Indeed matters. Matters the
Why didn't you
order-
raise this objection and got the issue decided that they should go under 33C2 for
order of the
computation?
Honorable CW of the rate code was of 2000. They have come in the year 2011. What we have extended long back in the year 1993 is much more than what they were pleading matters.
So
That is the honorable submission.
you just take it back and implement the award.
Matters if they are not, my
You take
submission-
it back and implement the award. Simple. If you have given them more, right? More than what they deserved under the award, you revise everything, recover it from them. What's the big deal
If
about
they
it?
are agreed by what we have given, which is more than what they are pleading.
No.
Application.
You see, it
33C2
is not important whether you have given more or you have given less. What is important is whether you have given as per the award.
Well, it's-
If it is more, You deduct it, recover it from them, recover it from their assets if they have expired. Do whatever.
One of the records will, the workers and tracing them will
We
be
do
something
not
not
know.
possible on our end. This is a submission which I am making. They were working since 1975. We have regularized the services, we have extended the benefit. It is not that we have not complied with the order of the CGIT or this honorable court. We have given more than what they were pleading.
Why
despite
did
their
you?
acknowledgement.
This is which company is this?
Well,
Who is
this is-
giving more than what they
This is
deserve?
Central Coalfields Limited, ma'am.
So why should
There was
there
a-
be an inquiry against you that you have given them
Well,
more
there
than
was
the
a-
award?
there was an
Let me just understand. Why shouldn't there be an inquiry against you that you have given them more than what they were entitled under
Well,
that?
because we have stated
Under
that
whose instructions did you give them more than what they
there was an
were
understanding
entitled?
with the union, my lords.
You
There was
understanding?
Union, my
Did
lords.
it end into a settlement?
Well, that we have stated in para 13 and
Is it a
14.
settlement?
Well, it's not written as settlement.
Boy,
it's written
if
as an
it is not a
understanding
settlement,
with the
matter
sponsor.
ends. No.
Understanding
If
with
it
the
is
sponsor.
not a settlement, the matter ends.
In that case, my lords, allow me a passover of one case, my lord. I'll ask my senior to assist my lords in this matter regarding that fact. What my lords is stating.
Your senior has taken this court for granted.
No,
You
my
don't
lord,
file
it's not.
affidavit pursuant to the orders
My lord,
passed by
it's
this
not
court.
legs in court,
You have
my lord,
wasted
therefore I was
just a
offended, my
moment. Okay. WPL number 7546 of 2011.
My lords, kindly
Counsel
allow
for the
me
parties are
a week's
present.
time, my lord.
Please hold on. In spite of order dated 26/2019, the respondent has not filed any affidavit. At the end of the argument of the petitioner, the respondent also commenced the argument and was trying to refer to the counter affidavit without giving any explanation as to why the order dated 26/2019 has not been complied. Upon being asked, he is seeking adjournment. Considering the fact that substantial time of the court has been wasted. The matter is adjourned. However, for the compliance of the order dated 26/2019, the matter is adjourned and is directed to be posted on 5th of December 2024. The affidavit be filed by 2nd of December 2024. Subject to payment of cost of rupees 10,000.
That's my kindly, my lords, just a passover of one case, my lords.
Don't waste more time.
My lords, we pass this order.
I'll increase the cost on you. Call kariye next case.
The affidavit was already there, Your Lordships. But that
No,
was
we do not know.
Lordship, can
You see,
that?
Mr. Das, this is not the way your junior would conduct a case.
No, Lordship,
He
I
will
don't-
argue the case full-fledged, and then when I put a question to him, he will ask that my senior will come. This is not the way. I will not
Lordship, I was
accept
on
it.
legs, Your Lordship.
When there is a specific direction to file an affidavit, why didn't you file it?
Lordship, that day also.
You
Lordship,
should have said that whatever has been said is
Yes.
there already on record. We
Lordship,
don't want
can
to
you
say
permit me
anything.
1 minute to show if it is not sufficient, Lordship, the order will stand. Lordship, kindly see.
No.
Lordship,
Study next case.
Lordship, we have also produced the pay fixation chart here.
You see, you do not know what your junior has argued. Do you know?
I was on legs in court.
So he should have prayed for a Passover. I would have given him the Passover. I would not have commenced the hearing.
Lordship, it
For
was-
last 25 minutes, this matter is going on. Chaliye, next call.
Passover is
No,
item
no.
21,
Lordship, the
WPL
cost part may be
4960 of
unless.
2012.
No, I will not
Lordship, he is a
take
new
the
incumbent. Lordship,
He is not a new incumbent.
Lordship, he has not completed 1 year.
No. In one day, you know what he did? Ask him. He mentioned a case which was not on my board. Ask him.
It is a mistake. But Lordship, in this
No,
case,
this was not a mistake. I will not accept it as a mistake.
Lordship,
Call
but in this case only cost part हटा दिया
Item
है.
नहीं
21.
हटाइए ना 20 मिनट मेरा बर्बाद किए यस
Lordship, then
ही इज नॉट a novice person please don't tell me
No, he has not completed 1 year. Lordship, that Lordship will check from.
no I don't need to
Yes.
he is otherwise very competent he understands what he says in the court it's not that competence will not be dependent upon the length of practice It will depend upon the understanding of the counsel.
Yes, Lordship.
He understands every word what I say, every word what is written in the records.
So I beg
very,
apology
very
on his
clear.
behalf, Your Lordship. Let it be, Your Lordship.
No.
This.
No, I
this-
will not change my order.
Or Lordship may do one thing, Lordship. I will deposit the cost, give the receipt, Lordship may remove it from the order sheet so that it doesn't affect. So I'll deposit the cost in wherever Your Lordship says. I'll bring the receipt and give it to the court master. Lordship may remove it.
Under what provision of law will you deposit the
Lordship, I'll
cost?
give it as a, if Your Lordship says that
No.
it has to deposit it with the Advocates Clerk Association. I'll
The
deposit
only
it
thing
there.
I can do is I can record your appearance also with the cost.
Record my appearance.
Yes.
Lordship, the cost part, if I deposit it, Your Lordship, then Your Lordship,
No.
Lordship is only, Lordship, that the cost is deposited. I'll deposit the cost wherever Your Lordship says. If Your Lordship says, I'll give it to the petitioner. If Your Lordship says, I'll give it to the Clerk Association or Jalsa and bring the receipt to Your Lordship and show it to Your Lordship that I've deposited it. It may not remain in the order, Your Lordship. It is a mistake.
See, we
I
can't
wanted to
come
come and I
pressurize
was.
you to deposit even
No,
a
no,
penny.
Lordship. Voluntarily, I will deposit it before Your Lordship rises. And I'll bring the receipt and I'll show it to Lordship and not record it in the order sheet. There is some difficulty there. It was there in the order sheet. It was not pointed out on the last date. I was waiting for this case. Unfortunately, Lordship, my matter to got called. I was there. I was waiting for this case. I wanted to show it at the very outset that there
You
was
see,
an
any
impediment.
counsel cannot take. When the court is putting question, they will say that my senior will come and argue. This is not acceptable to me.
He also
Because you do
asked-
not know what argument has transpired.
I was on list from there. I was
If a
messaging that
person
I'm coming.
if a person prays for Passover, there is no problem
Yes,
about it.
I understand. He should have.
It can't be like this. Junior will continue argue for half an hour and then when I put a question, when I want to dictate the order, he will say my senior will argue.
I beg apology. It will not be repeated. It has happened. I
He
need
is
to
not
question-
apologizing, only you are apologizing. I do not know.
There is lack of training from my part, Your Lordship. Therefore, I have failed in giving proper training, Your Lordship. I have not.
You had mentioned the case, it was not on my board. Why did you mention it? Why did you mention it at all?
I apologize, my lordship.
And I was asking him whether it is on my board. He said yes. I remember it so vividly. It was a case of ED or whatever. This happened, and then I was there in my chamber for half an hour, waiting for him to come. Tell him that no, your mentioning slip cannot be allowed. My court master has to confirm everything. It is not expected from your office, Mr. Das.
There is.
Whenever your junior is here, we assume that you are here.
I beg apology. There is a failure on my part.
Ask him whether it happened or not. I was looking for him thereafter. Thereafter, he did not appear before this court for 1 month. But I remembered that whenever he comes, I'll tell him that this is what he did. So this should not happen. अच्छा cost हटा दीजिए आप आ जाइए. ऐसा नहीं करिए. Don't ruin your career. You are a very good counsel. Don't ruin your
Make
career
him
like
understand,
this.
Your Lordship. It might not have been intentional. Make him understand.
कुछ दूसरा कोर्ट का मेंशन करती है यहाँ पर बाय सेइंग कि उसी कोर्ट का है कि इस कोर्ट का है और ऐसे मेंशन स्लिप अलाउ होकर दूसरा दिन कोई केस लग जाएगा हम एक ऑर्डर कर देंगे यहाँ पर फिर आपको पता है कितना बवाल होता है
जी,
फिर आप ही लोग बवाल करेंगे
सबको एक तरफ से Lordship.
दूसरे का बोर्ड का केस यहाँ पे मेंशन करके लिस्ट कराने का कोई जरूरत नहीं है आई आस्क्ड हिम 3 टाइम्स एट द टाइम ऑफ मेंशनिंग 4:30 बजे मेंशन किए पूछिए कॉल करिए
Item 21.
कॉस्ट हटा दीजिए
सॉफ्ट कॉपी
सॉरी
सॉफ्ट कॉपी
क्या चीज़ का सॉफ्ट कॉपी आपको
ये कॉपी मिला मिसप्लेस हो
क्या चीज़ का सॉफ्ट कॉपी आपको चाहिए
She does not have the file.
गिव हिम द फाइल
No, I have given him the number of decimals. I'll make sure that he gets a copy.
this petitioner has expired.
पता
As I am told that you indicated on the last day that the petitioner has expired. भाई आप last date में submit किए थे कि petitioner has expired. Somebody must have told you. Then why do you need time?
because I have to find my daughter.
What? Substitution. She was supposed to join duty. Nothing survives. उनकी जगह उनका बेटा ज्वाइन कर लेगा ड्यूटी. Then डेथ हुआ है ना petitioner का. As per your information. If this information is incorrect by any chance, you can file a petition for recall. I will recall it. But on the last date, as I am told by the respondent, that you had submitted that the petition has expired.
He had informed me that शायद उनका डेथ हो गया, पता करके बता रहे हैं
वो आपको बताया था
मेरे को बताया
जब तक हमको करेक्ट इन्फॉर्मेशन
तो क्या करना है बोलिए?
तो एक सप्ताह का टाइम दे दीजिए हम बता सकते हैं
The UPL number 4963 of 2012, counsel for the petitioner submits that.
या 2 वीक्स का
We shall verify as to whether the petitioner is still alive.
the what it is shown that the inquiry was fair and proper.
Up there, we copy file.
They didn't copy.
Post on next Tuesday in the supplementary court list.
Much obliged.
From supplementary list, item 1, WPL 4739 of 2001.
Pass over to you.
In addition, this case I have to say that
Are you seeking pass over? What do you need to say? Call the
मैं
witness.
बता देना चाह रही थी कि उसमें लोअर कोर्ट रिकॉर्ड का एग्जिबिट एविडेंस कुछ भी नहीं आया है एंड दैट विल बी रिक्वायर्ड टू बी सीन बाय मी अपॉइंटमेंट लेटर है सो आई वाज प्रेइंग जस्ट एट एक्चुअली नॉट टू वेस्ट द टाइम earlier occasion my friend submitted that he has been stated and he has retired
Yes.
no but yesterday I asked him and I also verified he is still 17 be getting and 1.5 year his service is left over.
WPL number 4739 of 2001. रिकॉर्ड से आया होगा इसके
Only the papers has come. I've just checked it. Exhibits and evidence that is not there on the record. If I'm correct, I'll check. And that at the time of decision, the judiciary will like to see that those documents. That the appointment letter giving false information, the evidence. Big page है.
The learned counsel for the petitioner, after going through the records as received from the concerned court, submits that only part record has been sent. The concerned exhibits have not been sent by the court.
Exhibit evidence.
Sorry,
Exhibits and evidence.
and oral evidences. Office is directed to call for the entire original records from the court concerned. Let this be very communicated to us. Post this case on 11th of December 24 for final under the same.
Madam, humble request 11 December. आगे पीछे कोई भी date में my
That's
friend daughter marriage is date.
10. 10?
That's fine. No,
What is the date of marriage?
10 is Sangeet and 11th is marriage.
Okay. We'll post it one week thereafter.
हाँ.
18. 19th को? Comfortable?
हाँ.
From daily list item 24, WPL 6871 of 2012.
Yes, petitioner.
Item 24.
This case only for next week I'm saying. Only for next week.
The learned counsel for the petitioner seeks adjournment. You are for the private party?
Yes.
The learned counsel for the respondent is present. अभी हम एक दिन ये बैक पेजेस वाला किससे काम कर रहा है? सौरभ से वो जजमेंट उसमें कुछ जजमेंट्स था वो उसमें काम कर रहा है.
Back wages gainfully employed.
Counsel for the petition seeks adjournment. Post on 28th November for final discussion.
Next week, as because the third week we are not available in us. Mr. Manish Kumar will assist in this matter, and he is not available in third week with us.
26th.
Not in third week.
That is the last week.
Last week is not available. Next week any day.
15 दिन से कोर्ट नहीं आएंगे.
नहीं next week any day. Next week he is available.
20 तारीख तो फिक्स किए थे.
20 को अच्छा 28. I'm sorry.
20 तारीख छुट्टी है. 21st.
Item 25, WPL 0795 of 2012.
Let's say for next week.
When do you want?
In the first hour, actually, I was informed by the fiscal lawyer that Mr. Misra will not be available today.
Oh.
However, now it has been informed that he will be joining by.
आप लोग ऐसा करते हैं तो गलत बात है.
My lord,
एक बार
actually-
बोलेंगे आज नहीं करेंगे.
नहीं, my lord,
Council will not get ready.
No, I told him right before lunch. He asked me. I said I don't know. Tata Steel has just sent me this file whether Mr. Mishra will be there or not. Right before lunch.
आपकी तरह इंटेलिजेंट थोड़ी है कि लंच के
My
बाद तक
lord,
अभी तक
they are
तुरंत
not
तैयार
senior,
हो.
he knows much more than I do. In fact, I contacted Mr. Mishra's office in
Next
the.
week में
so he
final
said-
disposal में रख दिया जाए.
Like, एक बात I'll assist you.
लीगल स्ट्राइक क्या पॉइंट है आपका नहीं पता.
ये एक्चुअली इलीगल टर्मिनेशन का केस है. एक दिन
Domestic
का
inquiry
स्ट्राइक
fair
हुआ
and
था.
proper?
एक दिन के स्ट्राइक पे डिसमिस फ्रॉम सर्विस.
काफी नहीं है क्या?
दिखाएंगे सर. दूसरा बात है कि नो सेकंड.
इनडिसिप्लिन तो हम एकदम ही बर्दाश्त नहीं
नो
करते.
नो सेकंड.
एक दिन का एब्सेंस भी काफी है कभी किसी को डिसमिस
No,
करने
no second support. The
के. The inquiry was held to be fair and
the
proper.
inquiry has been had to be fair, but I will show that there are some.
That order is also under challenge. Inquiry fair and proper.
Yes, it has been challenged in this rate, not separately.
It has to be challenged in this writ only.
Yes.
Separately तो cause of action वो तो सुप्रीम कोर्ट बोल ही दिया है
ठीक
कि वो fair and proper है कि नहीं है वो फाइनल अवार्ड होने के बाद ही डिसाइड.
ठीक
रिकॉर्ड भी आ गया.
ठीक है, हम कर देंगे. हम अपने
थोड़ा नोट फोर्स बना लेंगे. ठीक है.
ठीक.
The learned counsel for the parties are present. Counsel for the respondents we can do because you had informed him that you will sit in.
Right before lunch, he asked me whether I will be doing this case. I said I have the file right before lunch, after your lordship had received.
But
It's not in
The
my
learned
order
counsel
now.
for the parties jointly pray.
Let it be that.
Okay. Joint prayer. ठीक है.
ठीक है, कोई नहीं.
Pose this case for with the consent of the parties. Pose this case for final disposal on 21st of November.
My
Item 26, WPL 3402 of 2013.
सौरभ आपके किसी केस में अभी बैक पेजेस में कोई जजमेंट क्यों है? करेक्शन. वहाँ है ना? वो फाइल में जरा देखिएगा दो तीन जजमेंट्स हैं. वो जो डीबी वाला जजमेंट है तो डीबी वाला जजमेंट. यस.
Let's see, pass the second last time.
ठीक.
Item 27. WPL 5390 of 2014.
Not today.
Yes. My senior Mr. Jiten Tripathi is not available.
Who is your senior?
Mr. Jiten Tripathi. One is father advocate in Raj Hospital.
क्या मैटर है जरा फाइल तो खोलिए देखते हैं क्या मैटर ठीक है
मैडम इसको नेक्स्ट वीक में दे देना आज स्टडी
थोड़ा सा देखते हैं हम आप कर देंगे नेक्स्ट वीक बट देखते हैं क्या मैटर है क्योंकि नेक्स्ट वीक बहुत सारे मैटर्स रखे हुए हैं शॉर्ट मैटर होगा तो नेक्स्ट वीक को देंगे आप वर्कमैन हैं यू आर द वर्कमैन
यस
आपको हड़बड़ी नहीं है लगता है केस डिसाइड कराने का 2014 से चल रहा है मतलब तो और भी अच्छी बात है पार्टी को भी कोई मतलब नहीं What has he done?
It was a part of a mob matters that had vandalized the office matters. Pursuant to that, the charge sheet was issued. The inquiry officer was appointed. He did not reply to the charge sheet notice. Thereafter, the matter was decided by the.
He participated in the inquiry.
It was also published in the newspaper.
Or he did not participate at all.
No, nor any application for adjournment or anything was sent by the petitioner.
Any criminal case instituted against him?
No.
Criminal case was instituted. You see para number 8. बताइए कब करें अब हम पढ़ें
That the petitioner has dismissed.
नहीं कब करेंगे बताइए आपको तो टाइम चाहिए
Time next week will be.
क्रिमिनल केस तो इंस्टीट्यूट हुआ है See para number 8. However, main contention of the concerned workman was that when a criminal case was pending regarding alleged incident, inquiry should not have been started.
Para
Correct. Right?
that is different.
The learned counsel for the parties are present. The learned counsel for the petitioner seeks adjournment on personal ground of the arguing counsel, namely Mr. Jiten Tripathi. He submits that the matter may be posted next week. Post this case for final disposal on 21st of November. काफी केस लगते हैं और कौन सा केस नेक्स्ट नहीं है कौन पास होगा तो उनका तो एग्जाम हो गया हमारा आपके सीनियर आ गए
Item 26, WPL 3402 of 2013.
रेस्पोंडेंट उस समय आए थे ना इस समय respondent नहीं थी. Who is for the respondent? Mr. G. Mishra. Where is Mr. G. Mishra? Mr.
ऑनलाइन के लिए
इस केस के लिए रिक्वेस्ट है? नहीं, कोई रिक्वेस्ट नहीं.
जब हम लोग बात पे तो बनाए कि नहीं 25-26 के लिए डाला 25 और 26 दोनों डाला हुआ है व्हाट्सएप में.
रिक्वेस्ट कनेक्ट करने के लिए अभी है. यस
अभी डाले हैं. अभी डाले हैं. Communication through this mode is instantaneous. Right? आपको बोल दिए डाल दिए और अभी डाल दिए. मेरी आवाज आ रही है आपको? चलिए.
Wait. This is the application whereby the respondent management has declared its duty to disclose, means that the dispute is referred. And then thereafter after reference to the registration of the reference matter, the reference has been answered in favor of the management, saying that the closure was justified. There were demands were raised on 899. What has happened that it is a premises where the repair work of the Blue Star company carries on. Carries on repair work of the AC and other instruments supplying to the various units. Then the workmen made certain demand on 8/9/1977. On demand being refused, the matter went in conciliation. Now, on failure of conciliation, the reference was made by the state government on 8/9/1999. The term of the reference were whether to
After 20 years?
No, 2 years. After 2 years.
8/9/77.
97 demand.
77 लिखी.
97 demand and 99 will not be reference after 2 years. Then your lordship, this first gave rise to the BS case number 12 of 19. Earlier there was some dispute. That was the BS behalf shops and establishment act case was there regarding the giving benefits to the workmen. They were used to transfer the workmen, but the transfer was being resisted, and for that matter BS case was registered. Then they came out with the plea that it is the industry, therefore the shops and establishment act won't apply, and then the demands were there, and which was resulted in the making of the reference. That reference was made on 8/9/1999. Term of the reference can you see the award itself. Kindly permit me to place the award, which is annexure. The present reference has been referred by the government of Bihar for identification of an industrial dispute between the parties, white notification number so and so, dated 8/9/1999. The term of the reference is as follows: whether to retrenchment of workmen came in Annexure K an announcement of closure of the Blue Star Limited Jamshedpur on 8/9/97 in spite of the business is justified. If not, what relief concerned workmen are entitled to? After receiving the reference, the notices were sent to both the parties, and the workmen both parties appeared both parties appeared in the case and filed their written statement. The case of the management as per. With the written statement is that the present reference is not maintainable on the point of facts as well as on the point of law, and the Bihar government has referred the reference without applying its mind and having drawn the conclusion that the business of the company was continuing in spite of complete closure from 8/9/97, and after closure no any industrial dispute existed between the parties. Further stated that the management has forced the closure its establishment at Jamshedpur, so it was not worth retaining economically and administratively in spite of the various efforts and consequence upon the services of all the workmen and the employees of the Blue Star Limited Jamshedpur at 14 so and so State Mile Road, area Jamshedpur, and Bellevue building so and so is to terminated with effect from 8/9/97 due to closure. And in terms of the closure, the workmen were paid 1 month's wages and compensation payable as per the section 25A of the Industrial Disputes Act, and the management has followed all the procedure laid down for the closure of its establishment, and the workmen has been duly accepted the paid amount, and also the closure of Mr. So and so, some words are being the closure of Mr. Blue Star Limited, Jamshedpur. Hence, there has been no retrenchment of the workmen due to the closure of the company. There has been no retrenchment of any workman due to the closure of the company. Further, they stated that the closure of the unit at Jamshedpur by the management was bona fide, and it has for the benefit of the company for its survival, and the management has complied with the provisions of IDF for the complete closure of its management. Thus, the reference may be answered in his favor. As per the written statement, the case of the workman is that Mr. Blue Star Limited is a registered company under the Act, and it has several units in different parts of India, including in the unit at Jamshedpur, and its main factory. It manufactures several items and also the maintains those materials. After selling the same, the company was having a branch at Jamshedpur at the relevant time, where the concerned workmen were employed, and the company was running for the purpose of repair and maintenance, sale and installation job, and had workshop at Railview Building, Station Road, Vipsalai, and office at the Strand area, Karma, Jamshedpur. Further stated that the company has one board of directors for managing the entire business activity of the company across the country, and common profit and the loss account and common balance. The company has policy to make an attempt to transfer the employees on to be surplus to alternative jobs in the company, and the company has having 43% sale in the AC business in the country. The collaboration of the company of USA and total income of the company had gone up to 12% in the year 96-97, but the company adopted a negative attitude toward this unit at Jamshedpur, and the workmen had a registered union for the workmen to protect their interest. The company had dismissed the workman Mrs. Parthasarathy in 1997 and Mrs. Murthy in 1990, and both had filed BS case number 9 of 97 and BS case number 12 of 90 respectively, and former case was disposed. Former case was disposed after giving full relief. Similarly, D.K. Anthony filed a reference case number 12 of 88 and Mr. Murthy filed a reference case number 5 of 91 which are still pending. Mrs. Case Dera has also filed the reference case number 1 by 85 due to his illegal transfer, and he had also filed a complaint case under FJ case number 1 of 1991, and thus the concerned workman had to file several cases against the company, and the company was trying to give a wrong impression to harass the workman, but the union had succeeded in getting the award, and the said award was confirmed by the Honorable High Court. The company has been exploiting the workmen in various ways, and it adopted a policy of victimization. The company has sufficient potential and scope of business within the Jamshedpur unit, but the company has been attempting to get the work done through the contract workers and taking undue advance of less number of workmen in the unit. The company issued a closure notice on 8/9/97, and when the workmen went to join their duty on 8/9/97, they found the premises locked out, and they received a letter dated 5/9/97 of the closure, whereby their services were terminated in a modified manner, but action of the company after the said closure was still continuing, and thus the closure is not closure in the eye of law, and its business is continuing at Jamshedpur, having office at Pramod Nagar, Parsudi, to look after the work, and the company has appointed dealers and the contractors workers to do the job of the company. Further case is that the company had introduced VRS on 1/9/97 for the workmen in the eastern region, including Jamshedpur unit, with maligned intention, as none of the workers were found to be surplus for the VRS, and such scheme was not circulated in Jamshedpur, and hence the concerned workmen were retrenched from the service of the company with the maligned intention in the name of closure of the unit, and such act of the company is not justified, and the same may be set aside, and the concerned workmen may be reinstated in service with full back value. On the basis of the pleading of the parties, the following points are for consideration: whether the announcement of closure of Blue Star Limited in Jamshedpur 8/9/97 is justified, whether the concerned workmen were reported as per whether the concerned workmen were reported as per law, if not, what relief the concerned workmen are entitled to. In this case, management has examined only one witness, MW1, Mrs. Tarun Kumar Basu. MW1 has stated in the evidence that he was working as a manager accounts in the company, which was closed by notice of closure, and has supported the case of the management, but the management did not produce him produced the later on the cross-examination, and hence his evidence was expunged by the order of the court. The management has not filed any document on his behalf. On the other hand, the workman has examined two witnesses. They are WW1, Muhammad Bahabuddin, and WW2, Mr. S.B. Chakrabarti, and both the witnesses are among the concerned workmen. WW1 has stated in his evidence that he worked with the company for 28 years and was terminated with effect from 8/9/1997. And since then, he is unemployed. Further stated that he is the General Secretary of the Union who had raised the dispute on behalf of all the workmen of the company. He had supported the case of the workmen in his examination in chief. In cross-examination, he had admitted that he himself and the other workmen had received final settlement of ₹3 lakhs from the management after closure of the company, which is less amount, and they had filed reference case now for the proper wages received, which is pending before the Industrial Tribunal branch. Further stated in part 30 that Mr. A.K. Biswas was an officer of the company who is known to him, and Mr. Biswas was allotted a quarter number 15, some road, Pramod Nagar, Jamshedpur, and he had provided telephone by the company at his residence. Further stated that after closure notice, the work of the company was going on by the contract labor, but he cannot say the name of the laborers and their contractors, and the company did not engage him nor the work of the company after the closure. MW2 had stated that he was also terminated from the service of the company after illegal closure, and since then he is unemployed. Further stated that after the illegal closure, the company is continuing its work from the dealers and the contractors, and at Jamshedpur, Mrs. Narveram Agencies is doing work of the company, and Mrs. S. Malik, Mrs. A.K. Enterprises, and Mrs. So-and-so Sons have done work of the company at Jamshedpur till 2007, and those contractors did not engage the concerned workmen nor the work of the company at the instance of the management. Further stated that
such a detailed order इसमें क्या है? आप ऐसा थोड़ी है कि आप 15 पेज 20 पेज का पूरा top to bottom order पढ़िए. Just tell us what is the perversity.
Question is this: whether they have the further reading will disclose that the court has put the onus on a certain facts that it is for the workers to prove those facts. But whereas the law requires that those facts that the company is completely closed, or that the company has the other branches in the country, and the entire the provision is that if the company is at one branch is at loss, then it cannot be presumed that that has to be closed.
You have accepted you have already accepted the terminal
Under
use.
condition.
You have accepted the terminal use, and another reference case is pending for quantification of that terminal use.
LCR, in this case, whether the LCR,
order में लिखा हुआ.
that has to be seen by
What it is there in the order? तो आपको पढ़ाते हैं, पढ़िए.
No, when question is right, when a company can be closed, for that very purpose, my lord, if you also kindly see
You just
the
see.
evidence act.
Just a moment. Page number 58. Internal page 5. In cross-examination, he has admitted that he himself and other workmen have received final settlement of rupees 3 to 4 lakhs from the management after closure of the company, which is less amount, and they have filed a reference case for the proper wage revision.
So far the computation. That
Computation में आपको
that
doubt
is
आपको
that is the different aspect.
the point is you have already taken money. You should not have taken money at all.
Then the question will arise.
Yes.
Whether the closure was justified or not. If the closure was justified, then the other remedy goes. But they have chosen the other path.
No, why did you see? You should not have accepted any money at all. You can't have it both ways. This happened when? This happened in 1997. Closure. 97 में आप पैसा ले लिए, ठीक है?
Date is not there.
पैसा तो लिए ना, क्रॉस एग्जामिनेशन में आपका आ रहा है,
ठीक है.
ठीक है? You have taken money.
When? That's the question.
That is not a question. That is not a question.
That will be the question. That is not there.
That is not there. Did you say that you did not receive any money?
No. They have themselves admitted that. How I can say? The question is when they have taken.
So how does that
whether
make
they
a
have
difference?
willingly accepted.
Therefore, that issue is pending in another reference.
No, that is for quantification.
How is it possible?
They both are two different issues.
You can't
Both
have
are-
it both ways.
No, certainly they both are two different issues. If the closure is justified, then the other action will be illegal. But if the closure is unjustified, then certainly I will have to be a regular service and regular payment.
And what will happen to the payment you have received?
Well, that will be the adjusted.
That will be?
That will be adjusted if I succeed.
Adjusted 97 का payment अभी उतना adjust होगा यहाँ.
97 का payment that date we are missing. That is not on the record. That when the payments were made. When the payments were made, and actually it was made or not, but of course their statement is there, but I cannot dispute that. So whether it was made or during the course of the proceeding, because till the reference is made, there was no such payment. Otherwise,
You have been cross-examined and you say that the payment of 3 to 4 lakhs has been made, and then you have filed another reference case with regard to disputing the quantum of compensation.
Probably I am not clear about this aspect. But I see the reference was regarding closure of the company. So when a closure can be taken, if I succeed that the closure, to show your lordship, that the closure was not justified, then I will have all the benefit of the putting back in the service and all consequential benefits. And then what will be the age of retirement, that will be the subsequent question. But if I fail, then another avenue is there, so far the quantum of compensation which has been paid. I am clear to you. Therefore, there are two remedies available to the petition department on that. If I am able to show to your lordship that the closure was not justified, then certainly I will succeed in this matter. And if I fail, then certainly the another provision is there that will continue. There are one judgment, of course I was not expecting that it will be taken up today. The judgment
Sir,
is
आपको
there.
शुरू नहीं करना चाहिए. We have started, you cite the judgment. अब उस जजमेंट के लिए थोड़ी कोई डेट देंगे हम.
नहीं.
तो आपका जजमेंट कहाँ है? लेके आइए. ऐसा थोड़ी होता है.
नहीं.
You should not have started the argument at all. अभी हमारे पास 25 मिनट बाकी है. ये तो कंक्लूड हो जाता.
नहीं, I was not expecting. I said.
So you should have taken time immediately. Why should you? Why did you start argument? हम तो जजमेंट आपको कभी मना किए? नहीं मना किए. ऐसे नहीं होता. पीस मिल गया हम नहीं सुनेंगे. जब कंटिन्यूटी में सुन रहे हैं तो कंटिन्यूटी में जजमेंट बाद में लेके आएंगे, ऐसा तो नहीं होता. Counsel for the petitioner seeks adjournment. Post on 21st. No, 22nd for final disposal. Counsel for this respondent has joined the proceedings online.
Item 28, WPL 2672 of the 2015 along with item 29.
Yes, petitioner. Where is the respondent? And what is the matter about?
Matter is about dismissal from service on charges of absenteeism. One problem I have before your lordship starts, some NCR I have not yet seen. I would like this coming up.
That's it, fair enough. LCR has been received. If you want to go through it, you can go through it. There's no problem about it. How many days absence?
Lordship, it is about 90 days or something.
Reason?
He was undergoing treatment. He was ill.
Did you adduce evidence to that effect?
Lordship, the court will.
It is not willful.
No, Lordship, not at all.
Did you intimate them at any point of time?
Lordship, the cross examination he has examined, the rendered witness has been examined.
Sorry, Malad?
As he says, I don't know.
There were
Somebody
four.
don't have to say.
This was the fourth. Earlier he was charge sheeted on 3 occasions.
You see, it is
I
one
just
thing
wanted to see the records.
You just have a look at the record, there is no problem about it. But if an employee has a justification for absence, then you cannot terminate. If he has a justification, a person might be in coma, a person might be in hospital, he might be in jail. There are so many things which can prevent a person from attending.
Those things I am aware. Yes, if a person is in jail.
Or otherwise not well.
The absence is not authorized.
Not willful. Absence is not willful.
Yes, willful will also be included. Because
Absence is unauthorized, certainly, because no leave has been taken. But it should be willful, unauthorized. This is Parmar's case.
yes, I.
पढ़िए रिकॉर्ड पढ़ना है वहाँ बताइए कब करिएगा बेटे काउंसिल फॉर द पार्टीज आर प्रेजेंट हाँ ऑफ कोर्स दिसंबर में 2024 में 10 साल होने के पहले ये केस डिसाइड हो जाना चाहिए
13 का अवार्ड है बहुत प्रॉब्लम है
केस तो 15 में फाइल है ना 10 साल नहीं होने देंगे
I'm asking for
Lordship,
first
बहुत
week of.
प्रॉब्लम में है बच्चा
You are asking for first week off?
Yes, December.
हाँ ठीक है
लॉर्डशिप इसके बच्चा लोग का स्कूल छूट गया
2015 से स्कूल छूट गया तो अभी तक कहाँ है अभी स्कूल जाने का मन है इनको
17 ये मिलता है उसको 4 महीने
आप तो एक बार भी मेंशन नहीं किए डिड यू
लॉर्डशिप लिस्ट पे आता है बट
आप एक बार भी मेंशन किए कौन सा मेंशनिंग है जिसको हम डिसअलाउ किए इसीलिए आप ये सब मत सुनाइए कि इतना दिन से केस पेंडिंग है और हमारा सुनवाई नहीं
लॉर्डशिप ये नहीं इसका प्रॉब्लम
4th December.
मेंशन करने वाले का केस 1-2 डेट में 4 डेट में हो जाता है
हमेशा
हो जाता है ना
हमेशा
वॉल्यूम ऑफ ब्रीफ से आपको कोई लेना देना नहीं शुरू करने से खत्म हो जाता ठीक तो आप एक हफ्ता वेट करिए ही हैज टू गो थ्रू द रिकॉर्ड आप भी रिकॉर्ड देख लीजिए कुछ नोट बनाना है बना लीजिए
लॉर्डशिप उसका हालात ये है कि उस सिविल
आपका हालात सही है ना यू आर ओके आर यू ओके यू डोंट नीड टू सीक इंस्ट्रक्शंस रिकॉर्ड आया हुआ है क्या इंस्ट्रक्शंस आपको लेना है आपसे ज्यादा थोड़ी वो आपका क्लाइंट आपको 2015 से तो इंस्ट्रक्शन कई बार दे ही दिया होगा कि क्या केस है मेरा इंस्ट्रक्शन इज नॉट मॉनिटरी इंस्ट्रक्शन Learned counsel for the parties are present. Records of the case has been received from the concerned court. The petition, the respondent, workman has been dismissed. The concerned workman has been dismissed on account of absenteeism. The counsel for the concerned workman has submitted that there was justifiable reasons for absence, which will be proved before the court, and the award does not suffer from any perversity. Counsel for the petition submits that he wants to go through the records. ठीक है? First week December, post on
3rd and 4th.
3rd of December, final disposal.
Item 30, WPL 5133 of 2017.
Yes, madam. Tell us. What is your case?
What has been challenged my leadership? So several sand loaders who were workers of BCCL management, they had filed this. Means the reference was made for to regularize them.
Then what happened?
So they were not regularized on the ground that they were employees of the transport companies and not BCCL itself. So although their work was to excavate sand, and this place, it was on lease, it was given to lease to BCCL. So as they were conducting the work of BCCL, so they are claiming to be regularized.
Is there any law regarding employment of contract labor in excavation of sand?
The same NCWA.
No, I'm not talking about sand. There are certain kind of activities wherein there is a specific notification under the Contract Labor Abolition Act that they cannot be employed on contractual basis. Is there any such notification with regard to these employees? No, we will go strictly by the award. I'm just asking you, is that your
not
case?
aware.
What is the reason for refusal of relief to you?
The reason is that they say that we were actually employed or working under the transporters and we were transporting the sand. And so there were already contractors who were employed for that and we came under them. But the
So you
fact
were
is
not,
that we were,
according to you, they had offloaded their activity to the transporter or the excavator, and then you were employed by the excavator.
that is what they have interpreted it as, my leadership. But our case is that the lease was in the name of
Who was
BCCL.
making payment to you?
No, BCCL.
Okay, let us see where is the finding in the award. Where is the finding in the award that you were receiving the payment from BCCL directly?
Usually the award starts from page 85, annexure 11.
Yes, you tell us, you come to the finding.
Yes, my leadership. The evidences are there, my leadership. Para 20 at page 129, those are our witnesses only, my leadership.
No, there must be some finding in that connection, whether they have, what is the nature of your employment. We'll come to the finding first and then we'll see your evidence.
Leadership, it is at para 24, my leadership.
You come from para number 18. Para 17, the management denied the employer-employee relationship. You come from para 18.
The further case of the management is that all the names of the workmen was not in the reference, and fake persons might have come to make backdoor entry into the company if any order of regularization is made. It appears from the record that at the time of reference order received from the ministry, the names of the workmen is not received, And as the case proceeded from here to the apex court, during the pendency of the case mentioned by the parties that list of workmen is not enclosed with the order of reference. Therefore, after asking to the ministry, the list of workmen received by the tribunal on 8/7/2013. On perusing of the record and names of workmen, it is ordered to file identity proof of 1751 workmen, but the sponsoring union files only 1251 names and their photographs. It is also submitted by the sponsoring union that now claims of only 1251 workmen out of 1751 before this tribunal. In this case, on the behalf of the workmen, 4 witnesses have been examined, but their evidence is contrary to each other and prevaricating. Some say that they have been engaged by the management, and some say that they were working under contractors. They further say that they have no appointment letter and they have no identity card issued either by the contractor or by the management, though presently they have filed their photograph of 1251 workmen only. As per cross-examination of workmen witness 4, some part of cross-examination is quoted. I have gone through the tender, the agreement and other documents connected with the transporters filed in the present case. It is a fact that prior to engaging the contractor for the sand transportation, tender were being invited, and after acceptance of the tender, the contract was awarded. Cross-examination, some parties quoted below. I have got no paper to show that I was appointed by BCCL. I have got no paper to show that we were appointed by Agarwal Transporter. We have not filed those papers which are in our possession to show that we were working there. We have got no order to show that officials of BCCL had been given direction to us regarding loading of sand. Shri Chintamani Mehto, as a working witness 1, says in cross-examination that we have got no appointment letter and we were orally appointed by the owner of Ashok Transport. I do not know the full name of the owner. He also says that every Sunday the Munshi of the Ashok Transport used to make us payment of wages through Kacha Voucher. To my knowledge, no muster roll register was being maintained by the Munshi of Ashok Transport, nor he used to maintain payment sheet. He also says that no pass issued to us, rather only the challan was being issued to the driver, on the strength of which the truck was allowed to be entered into the political premises. He also says that I cannot say that the union which has raised this dispute has been registered or not. On the perusal of all evidence and documents, it is not possible to know whether they were engaged by the contractor or the management. The management flatly denied that the workmen concerned are not their employees, and they have doubts that they worked for filling of sand. The union at the time of conciliation have not given the names of all workmen or their identity. The cross-examination of workman witness 4 and workman witness 1 is very much material, and they have admitted that tender was invited, and after acceptance of tender, contract awarded, they are also saying that we are only contractor workmen and no gate pass or identity card was issued to us, and payment was made through Kacha Voucher. Hence, it is presumed that there is not employer-employee relationship exists. Therefore, it is not possible to know as whether workmen were engaged by the management or contractor. It is admitted by the sponsoring union in para 15 of the written statement that all the concerned workmen are working since 1977. It means now all workmen are about 60 years of age. This being the situation, this tribunal is unable to give any relief to the workmen. Considering the facts and circumstances of this case, I hold that the demand of Brahmin Vikas Shramik Sangh for treating Shri Hemla Mehtu and 1750 other workers as employees of Mrs. Bharat.
Tell me the perversity in the order. How is it perverse? What proof have you given regarding your employment under these? No proof. Even identity card was not issued to you. Kacha vouchers were used by the transporter to make you payment. Okay? Rather, your evidence is ex officio against you.
With these sand loaders, their work was to load the sand.
We are not in a public interest litigation. You raised a dispute, so it was for you to prove it. You failed completely. At least this award cannot be said to be perverse. Show me any perversity. आपको कुछ बोलना है? Or the learned counsel for the parties. District petition has been filed for the following relief. The learned counsel for the petitioner submits that the concerned workmen the learned counsel submits that the reference was made under section under section 2 capital A subsection 1 within bracket D of section 10 of Industrial Disputes Act. Subsection 2 capital A होगा ना? Industrial Disputes Act with regard to demand of Gramin Vikas Shramik Sangh with regard to demand of 1750 workmen along with Shri Hemant Lal Mehto through Gramin Vikas Shramik Sangh for treating them as employee of BCCL and pay them wages accordingly as per National Coal Wage Agreement. She has submitted that the specific case of the workmen was that BCCL requires sand for storing purposes in their collieries after complete excavation of coal from the coal stream, and the sand is an essential part of mining purposes, used in mining purposes. The workmen were the aforesaid workmen were engaged in the job of excavation of sand from sand beds and to load it in the truck of transporters engaged by management, and they were paid by the management, and therefore there was employer-employee relationship, and the reference was required to be answered in favor of the workmen. She submits that the requirement of sand by BCCL is a continuous requirement, and therefore excavation of sand for the purposes of BCCL is essentially controlled by BCCL. The nature of work is of perennial nature, and therefore the impugned award refusing to grant relief to the concerned workmen is perverse and called for interference. That is it. The learned counsel appearing on behalf of the respondent while opposing the prayer has submitted that the impugned award is a well-reasoned award. The witnesses, the concerned workmen completely failed to prove their relationship with BCCL as the employees of BCCL. Neither any appointment letter nor any identity card was produced. And further, it has come on record that they were being paid by the concerned transporter through Kacha voucher. And consequently, it has been well established, and consequently, the workmen failed to establish the relationship of employer and employee, and it was a specific case of the management that there is no such relationship. He has submitted that should be sufficient. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the terms of reference is as under. Court करना है schedule annexure 11 है, page 21/3/2017. This court finds that the sponsoring union as well as BCCL, they filed their respective submissions, respective written statement, and 4 witnesses were examined on behalf of workmen / sponsoring union and 1 witness on behalf of the management. Documents of the management were marked as N1 to N6, but no documents were marked on behalf of the sponsoring union. Para number 3 में, page number 123 में आपको मिलेगा. The specific case of the workman was that management of BCCL requires sand for storing purposes in their colliery. After complete excavation of coal from the coal seam, if gap created by excavation of coal is not filled up by non-carbogenous material, and for that purpose, this gap is to be filled by sand, which is sent through these excavation of mixing the sand with water, and this process is termed as stowing, S-T-O-W-I-N. And thus, the sand is an essential part of mining purpose. It was also their case that the management has several collieries in the district of Dhanbad, from where several tons of coal is extracted daily. Thus, management requires a big quantity of sand for their collieries. Para 4 में. It was their further case that the BCCL engaged several workmen for the job of excavation of sand from the sand beds to load it in the truck of the transporters engaged by the management, and they were being paid by the management. But the wages of the workmen was not regularized by BCCL. They made representation, but no benefit was, but the demand was not attended to by the management. It was also stated that the process of excavation of sand and loading was being done through contractors, but the fact was that the concerned workmen are really workmen of the management of BCCL, and in order to shrink their responsibility to ensure proper wages to these workmen, the BCCL is not accepting them as workmen. On the other hand, the management asserted that the reference was not maintainable and there was no employer-employee relationship between the management and the concerned workmen. It was also stated that the sand transport contractors are called suppliers of material into the establishment of BCCL. And there is an excluded group of contractors from the purview of engagement of contract labor in the establishment. It was also asserted that collecting sand from river and loading the same into truck or dumpers and transporting the same would not amount to mining. It was further submitted that the activity was being given to the contractors through tenders. And the contractors are required to ensure proper payment of wages and all benefits as per the provision of law applicable to engagement of labor by such persons, and ensure medical facilities to the workmen engaged by them. And they are also required to pay all legal dues. The learned court, tribunal hai, the learned industrial tribunal considered the materials on record and found that as per the list forwarded by the ministry to the tribunal much later, there was total of 1751 workmen, but the sponsoring union filed only one identity with regard to 1251 names and their photographs, and had submitted that the claim of only 1251 workmen out of 1751 was to be considered by the tribunal. The learned tribunal considered the evidence of the witnesses produced on behalf of the workmen and referred to specific cross-examination of the witnesses who and observed that their evidences were contradictory, and further none of the witnesses could produce any document with regard to appointment, payment, etc. Admittedly, as per the impugned order itself, no documentary evidence was produced from the side of the union. The learned court, after considering the materials on record, came to a finding that the relationship of employer and employee was not established, and consequently decided the reference against the concerned workmen. It was also observed that all the concerned workmen claimed to be working since 1977, and by that time the case was decided, all the workmen had attained the age of 60 years. This court finds that the learned tribunal has considered the materials on record. Admittedly, no documentary evidence as such was filed by the concerned workmen to substantiate their relationship with BCCL. Further, their evidence indicated that they were not being paid by the BCCL, but were being paid through Kacha voucher by the Munshi, by the contractor. who was engaged in transportation. Considering the totality of facts and circumstances and after going through the impugned award, this court finds that the workmen, having failed to establish the relationship of employer and employee, were not entitled to the relief as sought for by them before the learned tribunal through the reference. There being no perversity or illegality in the impugned award calling for any interference. Consequently, the same is revised. The same is dismissed. ये पैरा नंबर 18 से ना ये थोड़ा पोर्शन कोट कर देंगे, इसमें से कुछ हमको डालना है. This stands dismissed.